everyone. Welcome to the 9th episode of the TCLF One-On-One series. Through the One-On-One series, we aim to interact with the best legal professionals in India and abroad. And we're thrilled to have Mr. Surjendu Sankar as our guest for the 9th episode. Mr. Surjendu Sankar completed his undergraduate law degree from NUJS Kolkata in 2008. He is a former dispute resolution partner of Shardul Amarchand Mangaldas in New Delhi, and now practices law in Delhi as an advocate on record of the Supreme Court of India. He has represented a wide range of Indian and foreign clients and successfully handled numerous cases before the Supreme Court, various high courts, trial courts, and tribunals in India. He has also successfully handled several complex international and domestic arbitration proceedings and enforcement proceedings. It's an honor to have you here today, sir.
Thank you. Thank you for your kind words.
Now, sir, as a dispute resolution lawyer with an independent practice, how has your work life changed over the years?
Yes, I'm a dispute resolution lawyer. However, I'm dispute resolution lawyer from day one. So it's not a sudden change in my life that I have turned a dispute resolution lawyer. So the work life has I have been practicing, and I inculcated myself over the period of time. As compared to transaction lawyer is substantially different. I find it more exciting. And as a lawyer, you must have, and especially litigating lawyer, you must have certain additional features or adopt certain inherent work style in life. You should be organized, thinking ahead of the time. Those I have been trying to inculcate, and it's a matter of experience. And the more the time you spend in the profession, and more you're able to, perfect the, and fine tune those features. And if you ask me about particularly about my working life, of course, I'm early riser, and I love to start my day early. So that's why my junior colleagues always, they also get used to the similar, working style or work life. No one is nowadays surprised if someone receives a mail at 5 o'clock in the morning. So in fact, during lockdown also, most of the time I was getting up very early, sometime 5 o'clock, even before that, to proceed with the work. And reason being that what I feel as a dispute resolution lawyer, in your life, the kind of promptness you are required to give to your client, your matter to a court, is something different, and that makes you different from a transaction lawyer. And it's just a matter of experience and practice. So there's nothing particular, and there's no sudden change. With the more time you spend in the profession, you automatically get it.
Yes, in fact, you have over 10 years of experience in dispute resolution, and you became a partner in a top-tier law firm. In 2009, however, you left the firm and started your own independent practice. What inspired this change, and how has this experience been so far?
Well, that's interesting, because the independent law practice and chamber practice and a law firm practice, they operate in different spheres. So both of them broadly are to cater dispute resolution, but the working styles are completely different. Some places it may not be completely different, but to a major extent there are differences. So it's not that one is superior to another. It's never the case. But the way the works are functioned, how the people function as a teamwork, in a different structurized, organized manner, that has difference with independent law practice. While you say it's independent law practice, is not that I'm doing of my own everything, because I also need support from my juniors, my staff, my court clerk. So both the places is teamwork only, but working style, practice, procedure, I think it's substantially different in both the places. That's I'm telling you from my experience. Yes, I grew up in a firm, and I was privileged to become a partner in a top law firm in India. It was my immense pleasure. In fact, I must say, But what I felt that as a partner or being in a law firm, to some extent, you get deviated from the groundwork. What is groundwork in dispute resolutions? To stay connected with the matter, to be completely involved in the matter, which I've always loved to. Even if I was a partner, I always so involved, deeply involved with the matter, each and every matter. That kept my aspiration alive to get independence someday. And the term is independent practice. So to whatever you say in a law firm, your decisions somehow is controlled by someone, which is not there in independent practice. So there are pros and cons in both the places. But of course, I felt that you know I would be able to function better. Like, it's my personal view that I'll be able to function better if I'm working independently. And I chose to do that after 11 years. And yeah, it's more than a year time that I have been in independent practice, and got used to it already.
That's quite interesting. In fact, you mentioned the freedom that comes with independent practice. However, choosing the right time to go independent as a lawyer is extremely important for a litigant, and it's a very tough choice to make. So, in your opinion, what are some of the key factors that one must keep in mind before going independent?
Yeah, it's very interesting question, and in fact, I'm very often confronted with these questions across India. Law students, practitioners, they call and ask for the advice, and I love to discuss the points. See, there's no single criteria. If I objectively divide a criteria, I'll find first and foremost criteria is the financial support. Second is experience, and third would be clientele. And you should have balance of all these three criteria. Is with only financial support, with experience or clientele, you can't move. Similarly, with if you have experience, you don't have financial support or clientele, you can't move. And only clientele without any financial support is difficult to move as an independent advocate. So my advice is that there is no certain or particular time that you should know, let's jump into independent practice. It's your confidence level. You must analyze your financial position in your family, your how much experience you have gained, how much networking client you have. Those are the determining criteria to decide that now is a high time to start off your own practice. Nowadays, I have seen many youngsters, they're starting their own law firm, with a Latin name. It's very, very popular nowadays. So it's good to do that because it shows your venture, your entrepreneurship, many things. But alongside, you should keep in mind that without sufficient experience, the kind of difficulties you will face during the process will be I'll say that you can face it, you can confront, you can experience. But if you have a minimum level of experience and then start with it, I think your life will be easier than what would have been without much experience. So yes, there is no particular time frame in terms of years, but it's your comfort, your confidence level. I think that would make that will help you to decide the right time.
Yes, that's quite true. In fact, congratulations also on being appointed as panel counsel with various PSUs and government agencies. Now, what are the benefits of being empaneled with government departments and PSUs? And as you mentioned, experience is also important. So what is the minimum requisite experience for such designations?
So I have been representing various PUs from my day one of my profession. So I am familiar with their practice, procedure, the style of working is very important. So and of course, it's a matter of it's a sense of pride and privilege to represent government and public sector undertakings. It comes with certain disadvantages. Sometimes people say there is a lack of proper instructions. You know, the things, the documents are not coming on time. But I feel that it's up to the lawyer to make it up. because see what I'm telling from my experience, my involvement, my activeness with the client, interaction with the client, the follow-up, compel them to act promptly and they respond swiftly. So I've never complained that, oh, my government client is not responding adequately, properly. So it, I think, depends from person to person. And being involved, being empaneled with government and PSUs, uh, the biggest advantage is that it gives you regular flow of work. It may not give you substantial handsome remuneration, but there's a regular flow of work, and that keeps your you busy in courts, and that caters to your experience. That is what is required for for a practitioners. And there is no minimum sort of qualification requirement in terms of experience, but of course there are PSUs, governments, they want at least 8-10 years of experience. Without that, they don't empanel the lawyers, and there are different categories also: junior, senior, medium, whatever. So depending on that, one can fit into the requirement. Some people may have some contact somehow, you can easily get access or get empaneled. But for me, it has been always the work that I have been interacted with them, I've worked with them, and I know them. So they wanted me to be their lawyer, so I got myself empaneled and have been happily working with them. Having said so, I must also point out that I have seen the trend amongst the practitioners to discriminate between government client and private client, because of the obvious reasons of a fee scale which is substantially low in case of um, uh, government client. So I think that's completely unjustifiable. One shouldn't do that, because if you're doing that, it's against our professional ethic as well. And I'll give an example. Very recently, I had to issue a legal opinion on some contractual terms, amendment. So it appeared to be very simple query, but I read it, I dissected the proposition, went deep into it, and found several intricacies. I came up after slogging for almost 10 continuous hours with the sound opinion, which was appreciated by the client. So I could have finished in 1 hour and given a legal opinion. But I feel that we should never compromise the quality of work, irrespective of whosoever the client is, how much you are paid. So these are the factors you should keep in mind. So it's not only about a matter of pride or sense of pride to represent the government. It comes with responsibility. So I am hopeful that I'm able to discharge my all responsibilities effectively with the government clients.
Yes, I completely agree. You mentioned your work ethic and how important it is to maintain quality as a lawyer. And you've also specialized in domestic and international arbitrations, as I mentioned earlier. However, due to the pandemic, almost all court and arbitration proceedings have been conducted virtually. Now, as a practitioner, what are the key differences you've observed between offline and virtual proceedings? And what do you prefer between the two of them? And how have you been able to maintain your work ethic and interaction with clients in a virtual setup?
So this is the topic of the time, because everything is going virtual. And I recall that my virtual hearing was an arbitration, London-based arbitration, and it was in 2010. That time, you can imagine how much, what kind of video quality we have. So that was a convenience and a necessity for that. We had to conduct the virtual hearing, and right now it's a compulsion. So right now, if you look at the situation, it's out of compulsion. People are having virtual hearings. No one, like most of them, don't like it. But if you look at it very objectively, I think in arbitration practice, it's good to have virtual hearings, especially for the procedural hearings. There are pros and cons as well. In terms of pros, I can say that is very quick, effective. You don't have to travel across the country or some other part of the city. you end up not wasting time for tea or coffee, unnecessary discussions. So once you are on screen, is very focused. There'll be 6-7 heads and be speaking as per their term, and it's very smooth. But having said so, there are certain cons in the sense there may be some technical glitch, maybe some sound and picture quality. One of the lawyers, arbitrator may not have, a better quality camera, so it may not be visible properly. There may be some sound issues. There are cons as well, but I think right now we don't have much options but to go ahead with the virtual hearings. And if you ask me specifically if I'm happy, of course I'm happy, because at least hearings are going on. So and you have a time frame to complete the arbitration. Limitation may be extended, but a standstill in an arbitration is not good. So to the extent possible, we are able to progress with the arbitrations with different procedural hearings, and to some extent certain substantial hearings as well. We are happy to do that because ultimately matter will progress, and cases can be disposed of soon. So yes, it is out of compulsion, but of course it is a happy choice, I must say, to go ahead with virtual hearing.
Yes, I think lots of people, in fact, like virtual hearings, like you said, because of how efficient it is now. And just following from that, sir, what are some of the procedural and substantive issues you see that can arise due to virtual proceedings, like enforcement of awards or witness examination?
Yeah, you've very rightly pointed out. As I said, that procedural hearings you can have through virtual mode. But if you ask me frankly, cross-examination where witness, demeanor, and everything is very important, I don't find, that given an option, if you have to have a physical hearing, I would prefer to do that. Right now, if this situation continues, there's no option but to conduct through virtual hearing, the cross-examination as well. But there are certain drawbacks in virtual hearings in terms of cross-examination, and and substantial arguments as well, because your presence, your presentation, your appearance makes a difference which is not visible over a video call. So given those points, I would always recommend to have a physical hearing in terms of when you have a final arguments or cross-examination evidence stage. But if you are left without any choice in the pandemic, then you have to do it.
Yes, in fact, like you mentioned, that there's no choice. But apart from the advent of virtual proceedings, there have been a number of other legal trends in place as well. And one of them has been the fact that a number of arbitral awards have been set aside by the High Courts and Supreme Court of India. Now, what is your opinion on this development?
That's very important question. Now, so far as the arbitral award enforcement challenge is concerned, we must not generalize, because each award operates on its own facts, on the strength of its own facts and the grounds pleaded before the court. Now, if you see the recent trends, there are certain arbitral awards which were set aside. For example, NAFED in Supreme Court, it was a foreign award which was set aside. But I found that the grounds were justified by the court to say that compelling a government to perform something which is against which will be against the public policy, something like that, has certain merits, and they stand to say that the arbitral award should be set aside. Now, if you compare that with certain other decisions, for example, recent judgment on Incentro Trade or Vijay Karya, where the enforcement of arbitral were allowed. There are numerous judgments by Delhi High Court, Calcutta High Court, Bombay High Court, where the arbitral awards were upheld and the Section 34, 37 were dismissed. There are cases as well to set aside the arbitral award. So one should not think that it's an arbitral award, so all the challenge should fail. It should be upheld. That's not the case. And that's how we have the protection under Section 34, 37 and SLP. If the arbitral award is found to be against the public policy or certain other grounds available, permissible grounds available, sorry, then of course it must be set aside. So while we are approaching for a pro arbitration perspective, Indian perspective, but it's required to be balanced as well, because I have witnessed myself there are so many arbitral awards, they lack proper rationale to come to a conclusion. And I felt that nothing wrong in setting aside those arbitral awards. There may be other occasions where this is properly reasoned award and court should not interfere with, even if I'm on the other side. So a balance of that and an uniformity in approach by the courts is more important than how many awards are set aside.
Yeah, so that's quite an interesting take. In fact, just to conclude this, as a first generation lawyer and someone who set up their own practice, would you have any advice for aspiring litigators?
See, that's, I think, the burning topic of this month or this time, whatever you say. Yeah, first generation lawyer has its own challenges. Amongst the first generation, there is also, comparative challenges. There'll be debate about law school, non-law school, first generation, second generation, third generation, having got further connection, reference, so many, so forth. But there will be debates, and just accept the fact that the world is not fair. So, keep that in mind, and equally keep in mind there's no alternative to hard work and sincerity. And being particular about the matter, being a perfectionist and punctual is very important. You be first generation, second generation, doesn't matter. The sense of responsibility is of immense importance. You should own a matter. You should be completely responsible for it. And as I said, there's no alternate to hard work, and our profession is highly dependent on experience. So whatever work you are getting in hand, you must pay full attention and try to deliver your level best. And with your work should speak for itself. You may not have any network, may not have much connection, may not have a godfather to stand for you. But when your work, your assignment, your delivery, your approach to court, how you deal with your client, they are speaking for themselves. I think other debates become completely irrelevant. So, that's my advice to everyone, that work hard and pay attention to whatever work you do, in whichever forum, whatever matter, and whichever client is, doesn't matter. I think that's the mantra for success of each and every lawyer. Then I also heard from my seniors as well. So I'm just sharing my experience and what I learned.
Yeah, so that's extremely valuable advice. There really is no substitute for a good work ethic. And thank you so much for taking out the time on a Sunday to talk to us. And this has been extremely informative and helpful, especially as an aspiring disputes lawyer. And thank you so much.
Thank you so much. It was a nice experience to share my experience, and I hope some people will find it interesting. Thank you.